Want to welcome everybody to the FITSNews studio. We're doing another interview today. We've got a very special guest with us today. This is Steve Sumner from the Sumner and Todd Law Firm. Now, Steve is not only gracing us with his presence and his knowledge on a number of different issues related to driving under the influence law, boating under the influence law. So thank you for that. But more importantly, thank you for supporting what we're doing.
Oh, you're welcome, Will.
Your
Congratulations on what y'all have done.
No doubt. Your firm, one of the advertisers on our newsletter. Thank you so much for that. Also, I have to say this. I'm very jealous. You've got a killer domain name, upstatedui.com. Ours is terrible. I mean, this is a much better domain name. So.
Well, you're kind. We came up with that a long time ago. And Will, we did that because we're not just limited to Greenville.
That's right.
It's Spartanburg and Anderson and Lawrence and just basically in the upstate. So we just went with Upstate DUI, and it's wound up working out pretty good for us.
No doubt. Now, Lawrence, that's your hometown, right?
No, that's Scott's hometown. I'm from Greenville.
Oh, you're from Greenville?
Yeah, I'm from Greenville County, a little town called Taylors, which used to be different. I would want to say not Lexington, maybe Irmo compared to Columbia, which used to be a different town. Now it's mainly just Columbia. Taylor's is about probably 10 or 15 miles from downtown Greenville, and it's kind of been sucked up, you know, in the last 20 or 30 years.
So you're upstate, born and bred.
I am.
Okay, now tell us where you went to school. Tell us a little bit about the...
Sure. I went to Eastside High School in Taylor's, and then I went to Appalachian State University for 2 years, and then finished up at South Carolina. I was then actually a federal agent for about a year, and then I went back to law school after that at Carolina.
And before you hung your shingle out private sector, you had prosecutorial experience as well.
Correct. I was the prosecutor down in the 14th Circuit. I was a special DUI prosecutor on a federal grant, Will, where about 75 or 80% of my cases had to be either misdemeanor DUI, felony DUI, or traffic related somehow, maybe a reckless homicide or a manslaughter type case that came out of traffic. And those were the parameters for the federal government to pay in for 3 years for my salary. I did that for about 2 years and then went into private practice with a guy named John Hetrick in Waldoboro for 3 years, then came back to Greenville and opened up my own practice, and have been doing that since 1997.
Nice, but you got contacts all over the state.
Well, I do the best I can.
The legal community,
I do the best I can. And I was Democratic County Chairman in Waldoboro, and got to know Richard R. Pootley, and I call him Richard.
Yeah.
And Joe McCullough and Dick Riley and a lot of those guys back Joe Riley as well, back many years ago. Nick Theodore.
They've made names and fortunes for themselves.
They have.
Sure.
They've done very well. They've done a lot for South Carolina. David Wilkins and other folks like that.
Yeah, no doubt.
Absolutely.
We'll talk in a moment about the Mallory Beach case, about the boating under the influence action that really started this big Murdaugh murder story. But before we get to that, I've got a kind of dumb question. We hear about the laws, boating under the influence or driving under the influence. Help us out first. What does it mean? What is under the influence? Okay.
Well, first of all, that's not a dumb question, because if we went out, if you and I, Will, went out and walked, I won't say this, and walked down Main Street, Columbia, and asked 100 people, is it against the law to drink or boat and drive, you would see 100 hands go up. And that is really not the case in South Carolina. In South Carolina, to be under the influence, it's been given several definitions, Will. One is to be operating either a watercraft or a car, and it's generally a car, where your faculties to operate are both materially and appreciably impaired. Okay, and that is a jury question, Will. That is a question for the jury. And they'll look at a video, generally now we'll have videos, they'll hear witnesses, and they'll make a determination. It's also been defined as to being less able than a prudent driver would be able to make decisions under those circumstances. So it is not against the law in South Carolina to consume alcoholic beverages and to drive a boat. Or it's not against the law to consume alcoholic beverages and drive a vehicle. Are you impaired? Are you to the point where you can't operate it prudently? And I hope that answers your question. That is the line. We do not have, as I go on a little bit, hope not too long, we do not have a per se law in South Carolina. Some states do. If you register over, and I'll talk about that a little bit more in a second, But if you register at .08 or above, that is merely a piece of evidence. Right. It can be inferred by the jury that you're under the influence. However, you know, I've been a part of many cases as a defense attorney where a verdict was returned of not guilty well in excess of .08 because they look at all the factors there. They look at how somebody performs field tests. They look at how somebody speaks, how they talk, how they react, those type things. So a jury is told a person did register, let's say, you know, John Doe registers .10. The judge will tell the jury in a jury trial, you can infer that that person was under the influence. However, the presumption is that they're not under the influence. Right. It can be a little bit confusing. But is similarly, and I didn't mean to cut you off, and I know we'll talk a little bit more in a second, but the boating under the influence is very similar in South Carolina to driving under the influence.
So in both the boating and driving, that number, that .08, that's just one piece of the puzzle? That
is correct, yes, sir.
Okay, you talked about cameras a moment ago. Dash cam, body cam.
South Carolina was the first state to mandate video of DUIs, arrest of DUIs. Typically, the dash cam will start under our law with when the blue lights come on, it's automatically turned on. So you'll typically see the driving or some of the driving. You will see the interaction. You'll hear the interaction with a microphone. You will then see the person perform field tests. You'll see the surroundings. You'll see whether or not it was level. You'll see all the interaction. South Carolina was the first state to mandate the video requirement for DUI cases and for DUI arrests, DUI investigations. And so, again, we were the first to do that. So most every case now, you see there are exceptions. There are exceptions for accidents. There are exceptions for road checks. There are some exceptions in the law. But 85 to 90% of the cases that we would go and see or that any citizen would go and see at a local court would involve video camera.
Let me ask you about the body cams, because as a reporter, one thing that's frustrating for us is that a body cam footage is not something that we can obtain through FOIA.
Right.
It's up to the agency, the law enforcement agency, to release it or not.
Right.
If you're defending a case, is that the sort of evidence they have to give you?
Yes. Generally anything, and that's called a Rule 5, a discovery motion, anything that's a part of their file or a part of the prosecution will, in a case, they must turn over to the defense attorney once the request is made. And so, yes, I've never had a problem in getting all of the footage available on any particular case.
And I'm going to go out on a limb. I bet 100% of the time that footage is exactly as the client told you, right? Just exactly.
It's amazing. It's always the same. It's
uncanny.
It's uncanny how much it's like, I wasn't even on that road. And yeah, you were. You know? So sometimes, again, the initial interview becomes quite different when the person sees themselves, and sometimes it doesn't, but it can make for some comical moments for sure.
I bet, but you can still work with it no matter.
Absolutely, yeah, absolutely. You know, I mean, particularly now, Will, when you know we have cell phones, and that's something that wasn't a part of the landscape 10 or 15 years ago. So we are, I think, as a motoring public, we are distracted to a fair degree when we're driving. And so you've got the cell phone angle, you've got, you know, obviously, I guess I'm dating myself here. I'm close to 60. You've got radios, you've got things that you use to play entertainment in your car. Now you've probably got movies people watch while they're driving. So there is a significant distraction element there.
Right.
And it's not just alcohol or excessive alcohol. Again, I want to reiterate, reasonable consumption of alcohol is not against the law in South Carolina, but that is a jury question, Will, for them to determine whether or not you consumed it responsibly or whether or not you consumed it to the point where you're no longer a prudent driver and able to make prudent decisions.
Well, one of the things I want to bring you back down here in the coming weeks as the debate over medical marijuana advances at the State House.
Yes, sir.
A lot of the discussion within law enforcement circles is about impairment and how do we define it for for those other
That
drugs.
is an interesting point. When we talked about the .08, that is a threshold with alcohol. However, it is difficult, and to my knowledge, they've not been able, when I say they, I'm talking about the legislature, been able to define a percentage or X amount of nanograms or whatever is in your blood to determine a threshold amount for marijuana.
There's no standard.
Right.
Right.
There's no, exactly. Great point, Will. There is no standard. And then it becomes a jury question. And then you're thinking about, did somebody use marijuana 5 days in advance? Did they use it 8 days? Did they use it that morning and that afternoon or that evening? It just becomes a fact question, because a lot of people think that alcohol, and I think this is a good point that you brought up, that DUI is simply about alcohol, or BUI, boating under the influence. I know we're going to talk about that in a minute. That is not the case. It is alcohol, it is drugs, prescription or illegal, or a combination of both. So it can be an illegal drug, it can be illegal, it can be a prescribed drug. I've had plenty of what we call Ambien cases, where sometimes Ambien makes people do crazy things. They wake up at night, they don't remember anything the next day. You have prescription pain medication, you have prescription antidepressants, and there's a lot of things on the bottle when a person gets the bottle that says, do not operate heavy machinery, do not operate vehicles. So that becomes a question as well. And you can even be charged and convicted if you're taking it as prescribed.
Oh, wow.
Yeah, you can. And particularly when you, and again, what's the angle here, Will? It is for the safety of the motoring public. It's really not so much about what was always your condition is a factor, but are you putting other people at risk on the roads or in the water? And that's really what it comes down to.
And before we get into boats, let's talk a little bit about that. Obviously, more than 1,200 highway fatalities in South Carolina last year, another huge year.
Yes.
The government's Target Zero campaign obviously not moving us in the right direction, but how many of those are alcohol related? When you look at those highway deaths, what percentage is there?
I would say, I'm just off the top of my head, I would say something in the range of 20%. I don't know. I know that the pandemic has created a lot of pent-up frustration among the motoring public, among our citizens, and there has been a lot of documented incidents of just really crazy driving, crazy behavior. So right now, I think you could put some element of that onto the situation from a public health perspective that we've been going through.
So it's not just drinking, there's road rage.
There's road rage, that's a great point. There's road rage. I think we've all seen clips on various news outlets of just incident after incident after incident of crashing into a restaurant or crashing into, running from the police or whatever. And we do see a lot of that right now. I hope that from a public health perspective, if we can get a good handle, on the COVID situation, that will decrease.
Let's hope so, because the numbers are bad
now. They are.
Switching from roads now to the waterways, obviously South Carolina's got a 187-mile coastline.
Right.
Miles more rivers, lakes. It's obviously a state where boats are a huge part of people's lives. Obviously, there's different jurisdictional questions that come into play when somebody's operating a boat versus operating a motor vehicle. Tell us a little bit about what's the lines here? What do you look for?
Well, typically, you will see the boating, and it's called boating under the influence, okay? BUI versus DUI. The penalties are generally the same. I'm going to run through those kind of briefly for you. But DNR, the Department of Natural Resources, is who makes those cases on the waterway in every case I've been involved in, because they have complete jurisdiction over our lakes and over our rivers and over those things. Those come within their jurisdiction versus the Highway Patrol, or a sheriff's office that handles a roadway.
And this is a statewide agency.
Yes, correct. It is. I'm sorry. Yes, good point. DNR is a statewide agency. You know, we call them game wardens at times. I mean, that's what they do. In terms of the definitions of a BUI, and some of the listeners and viewers might say, well, what is the difference in a BUI and a DUI? And they're really very similar. The definitions of boating under the influence are materially and appreciably impaired. And I know that we've already, kind of talked about that. There is a different term, driving versus operating. And I want to talk about that for a second. Yeah. For a long time, the definition was driving, which would mean you would need to literally have the craft in motion, be it a boat or be it a car. Now the term in the statute is operating. Now, why does that make a difference? If you and I are out together and we're on a boat and we're both consuming alcohol, if the boat is put into neutral and you're still behind the console, you are operating the boat. And so therefore you could be arrested and subject to prosecution because you are operating the watercraft. You may not be driving at that particular moment, but you're operating. Let's say somebody in another boat, to continue this example, sees you and they feel like that you're operating or that I'm operating under the influence, or maybe you are, and they make a call. Cell phones are so common, and DNR comes out. And they pull their boat up beside our boat, and you say, hey, I wasn't driving. I mean, the boat's in neutral. I'm just standing here.
Doesn't matter.
You're still operating, okay? You are still subject to prosecution because you're operating the vehicle. There is a misdemeanor boating under the influence, just like there's a misdemeanor DUI first. There is boating under the influence with great bodily injury, as we maybe turn our attention a little bit to the Paul Murdaugh situation. There's great bodily injury, which is, and I want to talk about this for a second. That is a penalty if convicted of a wide range, and I want to talk about this for a second. The judge has the discretion, 30 days in jail up to 15 years.
Oh, wow.
And people might say, well, that is incredible amount of discretion to give a judge 30 days to 15 years. But great bodily injury has been defined. I mean, we think of it as maybe a near-death experience. It can be protracted use, loss of use of a limb, and I mean, that could literally be a broken arm. Why do I give that example? Because a judge would treat that differently. Okay, a judge would treat a broken arm that's fully healed differently than they would treat somebody in a near-death experience. So there is a 30-day to 15-year window there. Okay, death is 1 year minimum to 25-year maximum. And again, was the person I'm talking about things I've seen in my experience, Will. Was the person a passenger? Was the person severely inebriated? And that kind of brings in the legal term of assumption of the risk. I mean, hey, Steve shouldn't have been riding with Will. Steve was, Will was drunk, but Steve was more drunk, and we're going to take that into account with what happened. So you see a wide range of penalties. None, and that's exactly what it is, Will, for DUI. You also have fines that are associated with that. In South Carolina, for a boating under the influence, you often see a mandatory requirement that the convicted driver have to take a boater education course, which is a 6 to 8 hour course. In South Carolina, we also have ADSAP, which is an alcohol course, a 16-hour course administered by our local alcohol and drug abuse councils, Will, that are in every, there's a statewide agency, but they're in every county.
That's right.
It's a mandated program. It's the same if you took it in Darlington as it would be in Columbia or Greenville or, Beaufort County. It's the same basic curriculum. But there is a reckless boating, as we know there's a reckless driving, there's a negligent boating, there's a negligent driving. As it relates to Paul Murdaugh, because of the tragic and unfortunate death of Mallory Beach, it would have been a felony BUI. In other words, death resulted
he was hit
from the unfortunate.
3 of those,
Yes.
as a matter of fact.
Yes.
And faced, I believe, over 30 years in jail on just one of them.
Correct.
And by the way, if we ever go on a boat, you're in luck. I got 15 years sober, so you can knock a few back, you'll be in good shape.
Fantastic.
But looking at the Murdaughs case, again, there was a lot made at the time. This was sort of the incident that kind of exposed this whole situation in the Low Country with the family, with the firm. It was what began to draw people's attention to this circuit, to the influence that they had down there. But ultimately, we're talking about a crime.
Yes.
All that stuff matters, but when it comes to this particular incident, it's a crime. Tell us a little bit about what's your assessment. Obviously, there were some reports last fall. Dick Arpulin, you referenced a moment ago.
I did.
He and his partner, Jim Griffin, made some assertions to one of the papers down there in the Low Country about here's how we would have defended it. How much of that have you followed as far as the case, about the defenses they were looking at?
Well, I know a little bit about the case. I've read where the craft was going in the range of, I think it's been estimated between 30 and 35 miles an hour, something, and I would defer to you on that. I think you probably have more knowledge. In Archer's Creek, which is a very narrow body of water. I think any lighting that was used was handheld flashlights or something along that line. First of all, 30 to 35 miles an hour is a pretty steep clip in the water.
Yes.
I have been, and I'm sure you have been too, on a boat doing 35 miles an hour, and it's no mystery why people would be ejected from the boat upon striking, the bridge or the whatever was there.
It feels faster too.
I mean, it's fast. It's very fast. We know that that there were witnesses there. We've seen and heard from them about various, I don't want to say cut-up type maneuvers, but things that were alleged that Paul was doing while he was driving immediately prior to the crash. And we know that, and I neglected to mention this earlier, in a felony situation, a person does not have the right to decline any test. And I didn't really cover that, and that's because, I know we're a little bit limited in time here, but a person has the right to decline tests. They can they can decline the breath test, they can decline blood or urine, but not in a felony situation. They cannot. Okay, so we know that I believe that it's been reported that Paul's blood alcohol, I want to say, was 24 or something in that range.
Right. 3 times the limit we were talking about earlier.
Right, and that's not an unfair statement when you say the legal limit, because most people view it that way. But that's 3 times the amount from which a jury could infer that someone is
I want
guilty.
to tell us the term of art here. I want to make sure we get it right.
Well, I appreciate that. It would be an inference. It's not a presumption, and that is important. It is not. It's an inference that can be combined with other evidence. What would the other evidence be here, Will? Well, it would be the people on the boat. It would be the witnesses on the boat. It could be people that saw them. I believe that the group was at a bar, I think Luther's, if I'm correct. Luther's, the state might pull in 5, 6, 7 people that saw them at Luther's to simply say, I thought they were under the influence. I thought all of them were under the influence, and I wouldn't have ridden in a boat with them.
Right.
I mean, that would be more evidence. So you would see that. You would see the potential, any video footage, which I have not seen, of Paul, interviews, should this person have been driving, interviews of witnesses. So that would have been really what would have been the gravamen of the state's case should this terrible tragedy have not happened of his death. That would have been, I think, where you would have seen, I don't want to say plain vanilla. That's not really, I don't know if I'm getting that across right to our viewers, to our listeners, but that would have been, that's generally what is involved in a BUI or DUI prosecution, is what we'd call plain vanilla. It's not a document case, and I know that there have been a lot of documents regarding some allegations against Ellick in unrelated matters.
True.
it's not a document case. It's more of just a fact case of me, if I'm prosecuting the case of the witnesses. Are there 3 witnesses? Are there 5? Are there 7? Is there video footage? Are there people that say he shouldn't have been driving? We have the actual wreck itself, which is indicative of not being able to operate, you know, the way a prudent person would. And also we have the speed of the boat. So I think that would have probably been where Alan Wilson probably would have taken it. I don't want to speak for him, you know, but I think that that's probably what the bulk of his case would have been about.
Well, I wanted to ask you about that case. One of the things that surprised me in the immediate aftermath of that, we kept hearing that given the influence of this family, given who Paul Murdaugh was related to,
Right.
that we shouldn't expect too much from the Attorney General's office, that this was going to be a slap on the wrist kind of case, that there might be a reckless driving thing, but that Paul was going to get out of it. And indeed, if you look at the dash cam videos, where you see the law enforcement officers talking to the other people on the boat, you know, they're saying he's going to get away with it. He's a Murdaugh. What do you think you're going to get?
What are you going to accomplish?
Right. Based on, and again, I want to take sort of the politics and the public focus on the Murdaugh saga out of this. Just looking at the facts of this boating accident, when you saw the charges that were filed by the Attorney General's office, what was your response? Were they fitting?
No, I mean, I thought that they were taking it fairly slowly. They were, I think there's been, I think there's been allegations that some evidence was mishandled potentially at the scene. I heard that maybe even a family member of Paul took the boat and took the boat away. I think there were a lot of concerns regarding how evidence was handled. You know, to kind of follow up on that, if I can, Will, there's something called a chain of custody. And when you have physical evidence, you have to show who handled that evidence and how they handled that evidence from the time it was taken, picked up, until the time it was analyzed. And if you have a significant break in that chain, then you've got a real problem in that coming into evidence. And I'm sure that Richard and Jim were looking at every potential angle there, and the fact that when you have more than one person in a boat or in a car, particularly in a boat where ease of movement is much more likely to happen than in a car, where you'd have a compact seat or things like that, then you have to wonder who was driving. Can they prove who was driving at the time? So you have a lot of different things that the defense is going to explore.
So it would have been a tough case for the prosecutors.
I think it could have been. You know, I think, you know, obviously we're speculating here because of what happened, you know, down in Colleton County in a terrible, terrible tragedy. But, you know, I think there's a lot of room, you know, to work. And, you know, Richard is a wonderful attorney, as is Jim Griffin, so I'm sure they would have used every, you know, explored every avenue, zealously working for their client, which would have been Paul at that time, regarding putting up the very best defense that they could.
Definitely. It was interesting to me also in looking at the negotiations behind the scenes in the aftermath of those charges, because one of the things I kept hearing from my sources who were very close to this case was that there was no room to negotiate as far as the state was concerned regarding the plea.
Right.
And I think a lot of this was, again, this is before the Moselle shootings. So this was, obviously the case was at a very high energy level even before then. And I think it's important, as folks who have just started to follow the Murdaugh saga, a lot of them don't realize how big this was a big story before.
Huge case, big story. You do have a very prominent family, a very well-known family. You do have all the elements of, a William Kennedy Smith type, situation. I mean, I know you have the Kennedys, in the Northeast, and really their equivalent, so to speak. And I know the Murdaughs are very humble people, but they, you have that same dynamic present, and so you have Paul, again, a very high-profile person from a very high-profile family. A tragic death occurs. I don't want to say this because I'm not a part of the legal team on either side, Will, but you have aggravating facts.
Right.
I mean, you just some cases are not that way. This was aggravating facts in terms of the speed of the boat, where the boat was, and all the things that we've kind of touched on make it aggravating. We have a death. We don't have an injury.
Yeah.
You know, we don't have an injury. We have a death. We have, unfortunately, a beautiful young lady that is missing for, I think, a week or so, and then her body is unfortunately found. And then typically what you have then is you have a lot of victim input. And I don't know her family at all. I've seen her father interviewed. I've seen her mother interviewed. But when they stay behind something, when a victim stays behind something, the prosecutor has less room to move.
Right.
Yeah.
Because they're holding the prosecutors accountable.
They are. They are. Ultimately, it's the prosecutors. We do have a Victims' Bill of Rights in South Carolina where they get input, and they get input on a bond. They get input on at various stages of a case. Ultimately, it's the prosecutor's decision. But in reality, Will, when you have a family united and very vocal, about what they want to see, then they've got a client too. And typically their client is the state of South Carolina. But then it becomes a dual client relationship. Not only is it the state, it's this family. And that's what you see.
And not only the family, they are obviously represented by an attorney down there.
They are. Yeah, Mark Tinsley, I believe, represents them. And again, a lot of great lawyers involved in the case on both sides. And, you know, I think Mark, I don't know, but I know that you wanted to talk a little bit about the civil side of this. And I'll just go ahead and jump in on that. You have potentially, and I would certainly defer all this to Mr. Tinsley, but and maybe Justin Bamberg as well, and Eric Bland. I don't know Joe McCullough. I think there's a lot of different people.
There's a lot of them, aren't there?
A lot of different people involved, a lot of wonderful lawyers. You might have something called a dram shop action, where I believe there's video of Paul buying beer, alcoholic beverages, maybe a couple of cases of beer, or a couple of 12-packs of beer. You have potential liability. I believe it's alleged that a false ID was used. I don't know.
That's true.
And so you have potential liability against Parker's. I believe that the convenience store is Parker's.
That's correct.
In South Carolina, anybody that sells alcoholic beverages must carry a $1 million liability policy. So I'm sure that Mr. Tinsley is looking at that. There's also insurance on the boat itself, okay?
Which was owned by his father.
Right, there's insurance there. There's a potential of a negligent entrustment action, which we discussed a little while ago prior to getting this visit going. And that is whether or not, if the boat belonged to Ellick or belonged to Randolph, whether or not they were on notice that Paul should not have been driving the boat, or Paul should not have been in a position to be able to drive the boat. So you have that. You have potentially homeowners insurance that sometimes can apply. And you know, you've got going after personal assets. So there's a lot of, I think a receiver's been appointed. You have a lot of different areas that you can pursue, and I feel like that they will be pursued. I think that Joe McCullough, I believe, represents a person that might have initially, some blame might have tried to have been put on that person, whose name I don't remember, for driving the boat. I know that I think Joe's pursuing that, so pursuing that angle. So there will be a lot. Now the focus will go as it relates to the boating accident, and I know that there's been a lot of other things that have happened. The genesis, the boating accident, you're going to now see that shift because of Paul's death and Maggie, Ellick's wife. You will now see, I think, a big shift to the civil side of the case, and financial compensation, which is how we handle it in this country. You know, we
Yeah.
don't barter anymore. You know, I mean, years ago, as I may be drawn on too much, we would trade things out, and that was the way that things worked. We reduce, excuse me, we reduce things now to money, and
Yeah.
that's how we negotiate. That's how we buy gas and groceries, and everything we do is reduced to money. So now that will probably be at the forefront of that particular part of the case.
And the plaintiff's lawyers, you mentioned a lot of those who are involved, they stand to do pretty well on that.
Yes, they do. They do very well. There's some wonderful lawyers in that area, and I know Mark's partner, Woody Gooding, known him a long time, a wonderful attorney. I know Mark's a great attorney. There's a lot of really fine legal work from virtually every angle. In the case, you've got some of the leaders of the South Carolina bar in terms of reputation that are involved in the case.
Sure. And I know your time is precious, but as we want to ask you one more thing about, as we kind of pull that lens back on the civil action.
Yes, sir.
One of the things that we were talking about was how the focus is shifting from obviously the criminal case, which ended with Paul's death.
Right.
Paul was actually never charged civilly. There was an expectation he would be eventually.
Right.
But prior to his death, he had not been implicated in the civil action. It was his father who owned the boat, his brother who allegedly provided the fake ID. It was Parker's, as you mentioned, and then there were a few other establishments that settled
Right.
out of
Maybe
court.
Luther's.
Luther's.
I think. Yeah,
Correct.
Luther's, where they were immediately prior to
Right
getting on the
before.
boat.
But to me, one of the most fascinating components of the civil case has been to watch how Parker's and their attorneys and the private investigators they've hired have sought to handle it, because it seems to me there's basically two defendants standing. There's Parker's and then there's the Murdaugh family. And it's just been fascinating to watch the behind-the-scenes maneuvering by the attorneys, the investigators they've hired, the public relations people they've hired. But that to me leads us to, again, a question of, okay, there's all this spin, there's all this blame, there's all these stories floating around, but again, it's ultimately going to be a case based on the law. Tell us a little bit, and again, I know you deal a lot in defending on the facts of the DUIs, but the tort component, the shared liability, tell us a little about this.
Well, you know, in South Carolina, we have something called joint and several liability, which means that there can certainly be more than one party that can be deemed responsible for what occurred. It is not uncommon, Will, to see a lot of negotiating going on because you have varying degrees of culpability. I had mentioned the negligent entrustment action potentially. Was Ellick on notice that Paul should not have been driving? That would involve his history. That would involve, was it one incident? Was it 4 incidents? I don't know.
Should he have had access to the boat?
Yes, exactly,
Right.
exactly. Thank you for clearing that up. I might not have made that clear to the folks that are watching and listening. But how many incidents were there? Were there witnesses to those incidents? I mean, how strong can you put that together? You know, with Parker's, you know, it appeared to be a quick transaction from the video that I've seen. The two young men look a whole lot alike. You know, I mean, what you're trying to speculate in terms of the civil action, which is a lower standard of proof, Will, we talked about that. That is
Tell us
only,
one more time
that
for
is only 51%. Is it more likely than not that it is in favor of the plaintiff? Whereas criminal has been defined more in the 80 to 90% range beyond a reasonable doubt. So you have a very different standard of proof. But you're looking at this and you're trying to figure out what would a jury do. And you tend to see, or it's not tend to see, it happens 100% of the time, a whole lot more negotiating goes on with civil cases than typically with criminal cases, you know, because if you've got video, again, not to go too far into it, but if you've got video, if you've got 3 witnesses that saw somebody try to break into your home and they can be identified, there's not a whole lot of room to move on something like that. There's no real mystery as to what happened. But with what I've talked about, with the dram shop potentially, and that's DRAM, a dram shop action against Parkers for not using prudent and good solid business practices in the sale of the alcohol, and the negligent entrustment action that we just talked about. There's just a lot more room to maneuver on both sides, and there's nothing wrong with that. It's just people are trying to, lawyers and mediators and judges are trying to sort things out that are not nearly as clear.
Yeah, and as you mentioned earlier, it's ultimately it does on the civil side. It reduces to a dollar amount.
Correct.
In
it
most
does,
cases.
and a lot of people feel negatively about that, Will, in terms of, well, they settled for money. It's all about the money. Well, money is just how we operate. It's just how, if we're going to go buy a car, we buy it with money.
Right.
I mean, that's just kind of what we do.
All right. Well, Steve, I want to thank you for coming in.
Sure.
Also, again, thank you for your support of what we're doing here. It means
Absolutely.
a lot. It helps us do
And
what we're doing.
congratulations on the success that you've had.
Thank you, sir. We are trying, but definitely want to get you back down here. Obviously, we didn't get into the maritime law, which I know we want to talk about some point.
I do.
It's a factor.
And I'm glad to come back down anytime and talk about that angle of it, because it was not a lake. We were talking about an ocean, and we're talking about a creek, and we got to talk about that part of it, and I look forward to seeing you again.
No doubt. And we'd also want to get you, I was a little jealous. I looked on your website. I've seen you've got some columns in some of the other papers in the state. Would love to get you to share some of that wisdom on a guest post on FITSNews if we can convince you.
Absolutely.
We'll twist your arm on that. But
absolutely. Thank you, Will.
No doubt. Steve Sumner, Sumner and Todd, upstatedui.com. Again, a great URL for all your DUI needs. And again, he's going to be a regular guest on our program moving forward. So thank you, Steve, for taking the time.
My pleasure. Thank you, Will.
Yeah, man.
Take care.
Yes, sir.
All right. Bye-bye.